Yeah, so welcome back to everyone. And we can start with a new panel now. Our junior scholars this afternoon. The first time I read the title of this panel, International Courts and Tribunals in Crisis, I thought, well, this is the ICC. And we were discussing with Triestino a few minutes ago during the lunch break. And indeed, we will also have two presentations on the permanent international criminal court. Maybe we will discuss about it in the long table we will have in the afternoon later on. The question is this tribunal, the International Criminal Court in crisis? Well, most likely the answer is yes. In particular, it is a tribunal established 13 years ago, 14 now actually, whose credibility has been strongly affected in the last few years. In particular by the work, I think, of the Office of the Prosecutor. The tribunal, which has been accused very often to be an African international criminal tribunal, dealing only with African situations. Only last year, in 2015, the court has started this investigation in a different continent, which is in Georgia. But we have waited for more than 13 years to see the court working out of the African continent. Does this mean that international crimes are committed only in Africa? Well, most likely the answer is no if you look around what's happening today in the world. A tribunal, I would say, affected by the product of, well, the decision of the prosecutor is to think that the office has taken a few weeks to implement decisions coming from the Security Council, like the referral situation in Libya. The prosecutor, just 1 week, decided to open to request other scholars if Gaddafi, his son, and his brother-in-law, while it took more than 3 years just to reply to the request by the civil society whether or not Israeli armed forces were responsible in committing war crimes during the so-called Gaza war. And after 3 years, the prosecutor said, well, we don't know if Palestine is a state. Well, actually, he said something different. He said, could someone tell me if Palestine is a state in order to accept jurisdiction? But we could go on for hours with the other witnesses of these international institutions. Length of proceedings is not fault of the prosecutor. The difficulties in obtaining evidence. If you look at the situation in Kenya at the moment, for instance, you can see how the charges have been withdrawn for the difficulties of the tribunal to get evidence and to protect its own witnesses. And as I said, it will go on for hours discussing about, for instance, the lack of cooperation and the difficulties of implementing decisions, for instance, an arrest warrant, like we will see in a few minutes in the al-Bashir case. But I don't want to take abuse my role. So I want to give the floor to our first speaker, who is Carina. I'm sure she has something much more interesting than me to say, discussing about the efficacy of the Inter-American Court of Human Rights. Thank you.
Thank you. So my name is Carina, and I'm PhD candidate at the University of Manchester. I'm Brazilian, but I do have some Italian with me to make this studies even more interesting. So I'm here today to discuss some of the hypotheses that I've been developing my thesis about the efficacy of the Inter-American Court of Human Rights, and to present some of my findings. I have to say that this presentation, this thesis integrates a broader research project called the Sociology of the Transnational Institution, funded by the European Research Council, and it's by the Professor Triestino, University of Manchester. Well, I want to talk about 4 points today. Structure my presentation in 4 main points. The first one, I want to talk a little bit about the paradox in the human rights regime that is somehow related with this idea of a crisis in the human rights. The second point, and then I'm going to use a sentence that was said before this morning, that human rights in courts are not in a crisis, they are part of a crisis. So I want to discuss what is this crisis about, and I want to share the responsibility of this crisis, not only with tribunal and courts, but also with other actors. The third point that I want to make is that to understand the efficacy of international courts and tribunals, and therefore to understand crises, we cannot conduct an analysis purely formal, but we have to dwell on sociological variables. So I'm going to propose, I'm going to present the model that I'm using in my thesis, and I hope to have some feedback on that. And my last point, I want to present some of the case of the Inter-American Court of Human Rights, and with that I hope to shed some light on how the Inter-American Court has been contributing to the advance of the human rights regime. I'm afraid that I'm more optimistic than the discussion that was being realized here this morning, and maybe because I'm studying the Inter-American Court, and yes, there is an economical crisis going on right now, but if you look at the impacts of this court, it has this minimum budget, you can become more optimistic as well. So first one, I want to talk about this paradox of human rights crisis. So you have this asymmetry in the regime of human rights. On the one hand, you have these rights that are mandatory, constitutional, fundamental, imperative, use code. On the other side, you see these rights being violated all the time. And as someone was arguing this morning, they are violated, and what's the point about making some right use covenants if you're not creating reparations, if you're not creating a regime of enforcement that is being upgraded in the same level? Well, what I have to say here, quoting Nicholas Luhmann, that these rights, they are more known and assured in the measure that they are more often and gradually violated. So actually the crisis of the human rights is the excellent moment to the development and to the enforcement of human rights. So the crisis is also the solution of the crisis. And this is something that's not happening now. This is in the inherent nature of human rights, the paradox that has always been there. So you have the crisis, but you also have the solution of the crisis. So if you look, for example, about these attempts against the LGBTI rights that happened recently, this brought lots of attention to this issue as well. So in a moment of crisis, you also have a moment of solution and exposition of necessary issues. This is the first point I wanted to make. The second one, it's about human rights and specifically courts and tribunals being not the crisis, being not in crisis, but being part of the crisis. What we can perceive, analyze states, is that with the years, states became overburdened with issues such as migration, transconstitutional issues that have to be addressed, going beyond the state, beyond the capacity of the states. So this crisis that you have now in international court and tribunals, it's a crisis of the state. Sometimes we look at the state as they were like this monolithic entity, super powerful. We look states under the idea of sovereignty. But if you actually look not in a very formalist way, but if you try to understand the sociological roots of the formation of the state, you can perceive that this notion of sovereignty is more an illusion than a reality. So for example, looking at the Inter-American scenario, what you can see is that these states, they are not full sovereignty states. So what happens with international law? How international law acts within these states? It is true that sometimes international law has a disruptive effect on the states. So for example, if you look at FIFA effects, so how World Cups, how FIFA sometimes realize a World Cup can have disruptive effects on some countries, as for example Brazil and China. At the same time, and here I'm quoting California, Throughout modern history, domestic implementation of international law has often served to rectify weakness in national state structures and to resolve problems caused by neglected state autonomy. What is he saying here? He's saying that yes, sometimes international law can be can corrupt the domestic legal orders, but sometimes international law is serving to make the states stronger. And this is true. If you look at the action, if you look at the fact of the Inter-American Court in some of the countries of the region, what you can perceive is that judicial court are being strengthened. The right of minorities like LGBTI, like indigenous people, like indigenous women, is being reinforced by the action through the action of human rights law. So this is a very important point. If you really start to perceive that this constitutionalism that is being created beyond the state, and this constitutionalism is created within the state, they are close parts of the same process. As Professor Antonio uses a word that's really useful for this moment, he was talking about consubstantial rights. So somehow, international law and constitutional law, they are consubstantial. I know that often international law is presented as something that was antagonist to domestic law. But if you look deeply at the reality, for example, in Latin America, this is not true. International law is being formative, it's co-forming domestic laws, and it's reinforcing important structures in domestic societies. So the point I want to see that I want to make here is that international law and constitutional law are part of the same process, and therefore the full efficacy of a court, of an international court, of the International Court of Human Rights, does not rely solely on the action of the court. It does rely on structures of the state as well. By instance, if you observe, for example, the most violated articles in the cases that reach the court are the articles 8 and 25 of the Convention. And these articles, they tell you about the structure of the judiciary, the flaws in the judiciary in the states. And then, thinking that the full efficacy of a court does not rely solely on the court, you may ask, okay, so what are these other variables? In what does this efficacy rely? And then I want to propose this model of efficacy that I'm using in my thesis. What I perceive is, when you have a norm, any norm, and in this case, in some great cases, human rights norms, what you observe is that you have a chain of normative concretization. And this chain involves different actors and involves different layers. The layers that I'm trying to analyze are first, the layer of application of law. So who apply the law? Courts. And most of the studies, the commentaries in the court, they rely in this layer of the application of law, because they talk about coherence, they talk about loopholes, about standards. Some of the colleagues talk about uncertainties, ambiguities. So this is the layer in which the court has more autonomy. But you cannot observe just the application of law to understand the efficacy of the court. You also have to observe structures of force. And by structures of force, I mean normative, institutional, and societal conditions. Do I have a strong judiciary? Do I have strong norms? Do I have norms that people consider legitimate? After that, you have another layer that they call a layer of execution. Here you completely rely on the state. Is the state really complying with these norms? Does the state have the measures of enforcement, the internal ways to execute decisions? And finally, I have a final layer that I call adaptation, which means, is the society obeying to this norm, or is the society not paying attention to these norms? So taking into consideration this chain of normative concretization, instead of isolated cases or only the role played by the court, but all these actors, and observing issues rather than just isolated statements, we can observe two interesting phenomena. First, you do not have efficacy or non-efficacy. You have degrees of efficacy. In the same way, you cannot affirm, I have a crisis, I do not have a crisis. You have degrees of crisis. You have crises that are more stressed in some points, and the role played by the court and what's the role played by other actors. In this regard, I would like to now announce some of the functions that I think that are the primary functions of the court. That would be advancing the legal reasoning of some controversial points, or at least serving to provoke this debate in the states. I know that sometimes it's not the court that's going to give a final word on the subject. My colleague is going to talk more about that when presenting her paper on fragmentation. And I know that some authors saying, "Oh, we do have this, we have this postmodern anxiety in want a final word, in do not want this fragmentation." But sometimes this fragmentation can be positive because this can create debate on a necessary issue. Second, I think that the importance of the court rely in act as a complementary and more stable source of justice. And this is particularly important when we are dealing with overburdened states or states passing through transition. So you have the court and you can rely on the court and you have a more stable source of justice. And third, I think the court is also important when they empower local actors and transnational actors to act and litigate. And if you observe these 3 points, you can see that the court is doing its job. Well, now I would like to pass to some cases to illustrate how the court is addressing each of these functions. So the first case that I brought is a Chilean case. The name of the case is Olmedo Bassos of 2001. It's also known as the Fragmentation of Christ. It's a case about freedom of expression. What happened is that you had this movie talking about Christ in a society at that time conservative. What happened in the domestic scenario is that the Supreme Court of Chile said that it was okay, that the Supreme Court has upheld the censorship of the movie. So litigants brought this case to the court, to the Inter-American Court. The Inter-American Court reverted the decision, and then you would think, okay, what did Chile do? Seeing that, well, Chile proceeded with an amendment of the Constitution. And you would say, how can a state do that? They do not have ways of enforcement. Why would the state obey? Well, Chile obeyed this case, in the second case involving freedom of expression, and carrying out a constitutional amendment. Thank you. I was going to tell about 4 cases, but I'm going to just finish with the last case. I'm sorry. So I'm going to talk about amnesty laws. As you know, in Latin America, lots of countries, they have amnesty laws. And the court has been deciding that amnesty laws are illegal, they are illegitimate. And then in countries like Peru, and like Uruguay, and like Chile, these amnesty laws, they were declared illegal. Even in Uruguay, and in Uruguay with the case Helman, what happened was that they had carried out some referendums, and still Uruguay just declared amnesty law illegal against the decision of popular demand. So what I would like to prove in these cases is that yes, definitely we have points to improve. Courts, international courts do have points to improve, but there are certainly points to celebrate. These institutions have been provoking dramatic changes in societies and in the regional scenario. And maybe if we're passing through a crisis, at least this is a visible crisis now. It's a crisis that we can deal not only with political action, but with legal instruments. Now we have a normative and institutional framework to deal with these cases.
Thank you very much for this very interesting presentation. I think we can also now give the floor to Daniel Wong from the University of Leeds, who is going to provide a critical assessment of the ICC jurisprudence in relation to the al-Bashir case and the consequences for international criminal justice. Please.
So I take a bit more of a critical note in relation to the ICC. So I think the ICC is much more flawed than perhaps other courts in the international sphere. But I have to say at the outset, I deeply believe in the work of the ICC. I think it's an important institution. And hopefully by uncovering the flaws, we can help it to work better. So the paper I'm going to be presenting today is entitled "The Frog That Wanted to Be the Ox: The Indictment of Omar al-Bashir and the Consequences of International Criminal Justice." And this is part of a larger question that I'm seeking to answer, which is, what is the relationship between emerging states, I think from the BRIC states, and the International Criminal Court? And how does that relationship affect the functioning of the ICC? And perhaps more pertinently, its sustainability. Because one of the fundamental things that underpins my research, I think it's very important to recognise, is that the long-term sustainability of the International Criminal Court is not secure. It's far from guaranteed. I heard Jeffrey Robertson's QC speaker a couple of months ago, and he said perhaps the Israel-Palestine case is going to break the ICC. It could be the end of it. And I agree. It's a couple of wrong decisions away from a slippery slope to oblivion. And what I try to do is use my empirical work to answer a larger question, a more abstract theoretical one, which is, what's the nature of international society? How does it change, or why does it change? And from that, you can probably gather that my research works at the intersection of international law and political science. So, in this paper, which is an early stage, I consider why many African states in the AU contest the International Criminal Court's prosecution of Omar al-Bashir, the current president of Sudan, going on to look at the consequences of that for the ICC and for international criminal justice more generally. And I argue that African states perceive the ICC's reasoning in the al-Bashir case as incorrect and unconvincing in denying al-Bashir immunity from prosecution in court. And I also argue that the court's actions in that respect had a detrimental impact on the state's perception of the court's legitimacy. This has then affected the court's compliance pull, which is the ability of the courts to maintain the cooperation of its member states. And so I divide the paper into 3 sections. I'll first tell you a bit about the background of the case, explain how African states have responded to the ICC's treatment of this case, look at why the states have responded the way they have, and then finally, hopefully, I'll get to some of the consequences of those decisions. So, the UN Security Council referred the situation in Darfur to the ICC on the 31st of March 2005 in accordance with Article 13b of the Rome Statute. For those who are not familiar, that's the provision where non-state parties can come within the jurisdiction of the International Criminal Court. And this followed the release of the Commission Inquiry report, which confirmed that gross human rights violations had been committed in Sudan and implicated the Sudanese government. And after conducting an investigation, the prosecutor at the time sought an arrest warrant for al-Bashir. And this was always going to be controversial, because what was essentially happening is that the head of state of a non-state party was going to have his immunity stripped from him, that he would otherwise have under customary international law. And as I'm going to go on to show, that there's an argument that was raised by Sudan and other African states that wasn't lawful, that there was no power of the International Criminal Court to do that. Now, when the court issued the arrest warrant, it confirmed that it did have jurisdiction over Sudan by virtue of the Security Council referring the situation to the court. And it said, and I quote, "That is despite the fact that it refers to alleged criminal liability of a national estate that is not party to the statute, for crimes which have allegedly committed in the territory of a state not party to the statute." And it went on to confirm that the current position of al-Bashir as head of state, which is not part of the statute, has no effect on the court's jurisdiction over the present case. What the tribunal didn't do is it didn't establish the legal basis for that reasoning. It simply said, the Security Council's referred it, everything's okay. Sudan comes within our jurisdiction, and therefore Bashir can be prosecuted. And this same position was confirmed in the subsequent judgments of the court. And in the later judgments, it adopted a more nuanced position, but along similar lines, where it said the Security Council, by its resolution, stripped al-Bashir of any immunity he would otherwise have under customary international law. Now, African states, well, even before the arrest warrant was issued, African states were very wary of what the court was going to do. It knew kind of what the interpretation was going to be. and a statement released before the arrest warrant decision was issued, the AU referred to the need for international justice to be conducted in a transparent and fair manner and in line with principles of international law. And the head of the AU at the time said that Africa wasn't against international justice, but that it seems it has become a laboratory to test the new international law. So African states were expecting the court to be pushing the boundaries in this case. And when the arrest warrant decision was issued, there was a really strong reaction to it from African states. They initially said, right, we need to raise this issue with the Assembly of State Parties to clarify how Article 27 works and how it works together with Article 98 of the statute. They decided that African states would no longer cooperate with the court, particularly in respect to the arrest and surrender of al-Bashir. We saw lots of highly critical and vitriolic rhetoric coming from African states from the AU. And we saw lots of references to undermining the sovereignty and the dignity of African states. There were references to neo-colonialism when talking about the court's approach. African states challenged the reasoning of the court through a number of judgments when the cooperation of states came into question. And more recently, we've seen states threatening to leave the ICC, and even more recently, states taking even more concrete steps towards realizing that objective. So then the question is, what are African states' specific objections to the approach adopted by the ICC? And the first one is that the UN Security Council doesn't have the power to remove al-Bashir's immunities. And this was argued in front of the court on numerous occasions, and it finds support in the ground with a number of academic commentators. For example, Calabria argues that the UNSC resolution merely established the court's jurisdiction over Sudan and does not and cannot put a non-state party in the position of a state party, and therefore make it subject to the provisions of the Rome Statute. And building on this work, Assakiani argues that the UNSC referral can't have the effect that the IC says it can. And he gives three reasons for this. First of all, that the ICC is not competent to receive Chapter 7 powers as an independent institution outside of the UN system, unlike the ICTY or the ICTR, which were established within that system. Secondly, he says Sudan can't be compelled by the Security Council resolution to comply with the ICC's arrest warrant. And thirdly, adds a further gloss to this and says that even if the Security Council did have the power to do that, it didn't do it within this resolution because it failed to do so expressly. You can't have an implicit stripping of immunities by the UNSC. And finally, he said that you can't make a non-state party subject to a treaty, because that's a violation of the fundamental principle of international law that states are only bound to meet those rules to which they have expressly consented. And I agree with Gaeta and Kliani's reasoning in this respect, and primarily because lots of the reasoning on the other side is highly unconvincing. But also, it's important to note this: that if we accepted that was the case, the Security Council would have the ability to fundamentally alter the structure of international society by making states subject to treaties which they haven't consented to, and by displacing fundamental norms of customary international law. In this respect, the Security Council would essentially be acting as an all-powerful constitutional-like institution of international society, which I say it is fundamentally not. The argument that's put on the other side is, well, the Security Council can authorise war. That's the most destructive thing that can happen in the international community, and therefore it must be able to do anything else. Well, no, it can't. Because states agreed when they created the UN system that the Security Council would have jurisdiction over peace and security issues. The same isn't the case when we're talking about the immunities and its relationship to customary international law. The other point that was made, and I don't have time to go into this, is that states can't be forced to arrest the head of state of another state, because to do so would mean they act in violation of the law of customary international law which affords heads of state immunity when travelling to other states. And the bigger point, to move away from those very specific legal arguments, is this, that African states are contesting the ICC in the way that I've described, because they see its actions as posing a threat to pluralist and positivist world order, which is state-based and upholds the principle of sovereign consent. As such, they're seeking to defend this world order based on sovereignty against what can be said as the court's creeping cosmopolitanism and constitutionalism, and it's pursuing justice at the expense of everything else. Now, sometimes I sympathise with the ICC in some respects because the ICC is caught in a catch-22 situation. It has a huge expectation on it to arrest and to prosecute tyrants, not to focus on low-level criminals. But at the same time, in order to be able to do that and break away from the shackles of the state-based society in which it's created, it has to push boundaries. But by pushing the boundaries, it's contested. So it's always going to lose in some respects. And this is what leads me to say, this is the court that is a frog, but which is trying to be an ox. One other major criticism of the court in this respect is that its judgments concerning Bashir have been incredibly poor. As I said initially, it failed to articulate the legal basis on which it was removing immunity by virtue of the UN Security Council resolution. In its subsequent judgment, it tries to give better legal grounding, but fails to do it very well. None of its judgments are very robust, none of them are very detailed, they're very superficial. It states that it can do this as an uncontroversial matter of legal facts, which it certainly is not. These are complex legal issues that it really needed to interrogate, and it failed to do so. And by failing to interrogate these issues, the perception from the African states was that it's just imposing law upon us. We have no say in this. We've raised arguments and you're not listening to us. And that factors into this neo-imperialist critique African states raise. It's a liberal institution imposing a new vision of world order upon us. So the consequences. Well, as I said, the court's actions undermined African states' perception of the ICC's legitimacy, or its affected its ability to secure cooperation from those states. This lack of cooperation is that they've not arrested al-Bashir. As you probably know, al-Bashir travels around Africa with relative impunity, bar the incident in South Africa not too long ago, but that was a minor blip in the wide context. And this has prompted questions about the court's authority and its usefulness. If the court can't arrest the biggest criminals, what's the point in having the ICC? The ICC's action also galvanised African ICC, anti-ICC African sentiment. And that's been contributed by the Libya case, the Kenya case, which I mentioned. It's also prompted the ICC to seek to have Article 27 of the Rome Statute amended to exclude sitting heads of state. And while we haven't got very far with that at the moment, as a pushback from other states, African states continue to bang on the door. So that norm is under threat. And it's also under threat for this reason, that the court's approach in respect to the al-Bashir case and other cases has galvanised African support for the African chamber of the Court of Human and People's Rights. Now, that's a problem because it's unlikely, if and when that body comes into being, it will work effectively. If it does work effectively, it still has this problem. It doesn't have an equivalent Article 27 provision. Heads of state, sitting heads of state, will be immune from their jurisdiction. So I'm out of time, but I'm just going to list this quick conclusion. The approach adopted by the ICC in prosecuting al-Bashir has been, in my view, ill-advised. It's gone too far, as I said, in trying to achieve justice at the expense of maintaining the state support that it needs to survive. If African states withdrew from the ICC en masse, which is unlikely but might happen, it perhaps the end of the ICC. So as I said, to try to do too much in a world order which it can't support. And as we know from Reading Stop Spain, when the court or someone tries to be something they're not, it's ultimately going to result in a downfall.
Thank you very much, Daniel. You gave us a lot of food for thought, and I'm sure there will be questions. At least I will. Now we can give the floor to Alessandra, who will talk of expressivism and theory of punishment in international criminal justice, particularly before the International Criminal Court. So in part, these two presentations are linked. And another easy topic. You have the floor, Alessandra. 15 minutes, and I will keep on being this.
Non sei?
We won't count this. It's 2 minutes for me. Oh.
So, hello everyone. Thank you so much for having me here. My name is Alessandra, and I'm a third-year PhD student based in Strathclyde University in Glasgow. So, today's presentation is part of a wider project that looks at how the labor of victim participation is transforming the proceeding before the ICC and more generally the criminal justice system. And ultimately, my goal is trying to strengthen the victim's right to fair hearing before the ICC. But however, today I will go over an analysis of features and pitfalls of few criminal justice systems, based mainly retributive, restorative, and expressivist system, in order to identify which one can clarify better the goals of the proceeding in the trial, as well as the goal and mainly the scope of victim participation before the ICC. So, for the first time in international criminal law, the ICC conferred upon victims with Article 68, paragraph 3, the right to participate in the proceeding with an autonomous standing. However, the problem is that if you read the wording of this article, the ICC has the chambers has a very broad discretion. In fact, they can decide what is such a participation entail. So which rights this victim can exercise in the trial, and also which stage of the proceeding they can exercise this right. The reason why it happens is because this article, as well as all the statute actually, is the outcome of years of negotiation between the two main Western traditions, the civil law one and the common law one. And when it comes to victims' participation, according to common law tradition, victims can serve only as witnesses. On the contrary, the civil law country acknowledge that victims can take part in the proceeding, also as a civil parties. And the problem is the practice of ICC. The chambers didn't provide so far any consistent pattern when they address the scope of victims' participation. So we see that the place of victims within the criminal proceeding raised many questions about the purposes, the goals of the international criminal system. And clearly, having a clear understanding of the goal of proceeding of criminal justice system can shape the proceedings and also the role and rights of all the individuals, so including victims that are involved in the proceeding. So the question that I'm trying to answer today is which theory of criminal justice system clarifies the goal of the trials of the proceeding, as well as the goal and the scope of victim participation before the ICC. So, the ICC statute, particularly the preamble, seems to suggest that retributivism is one of the main goals. In fact, it states that the most serious crime must not go unpunished, and that the effective prosecution must be ensured. However, the problem with retributive theories, by the way, I'm simplifying because there are many different theories of retributivism, but now because I have just 15 minutes, so I have to go now. So, however, retributive theories marginalize the role of victims because the main focus is to convey the social condemnation of the criminal action, and therefore the important point is the perpetrator deserves to be punished because the behavior he committed is wrong. So the focus of this theory is on the defendant and on the wrong he committed, rather than on the harm experienced by the victims. Therefore, the proceeding takes shape as a dispute between the defendant and the state that represent the social concern. So, in retributive system theories, the courts base their punishment basically on two main criteria. The first one is the seriousness of the crime. So that means that punishment has to be proportional to the entity of the crime committed. So if you think of the ICC, how can the architect, for example, of such atrocity, how can it be possible to give in to this a proper punishment? And so if you think about this crime, it's clearly that it's impossible to provide the defendants with a proportional punishment. I think this proportionality requirement, in my opinion, raises a kind of paradox. Is probably the most proportional punishment would be death penalty. But clearly we go all the way in kind of human treatment. But of course it goes against like international law and human rights that clearly advocate against death penalty. And the second criteria is the mental state of the offender. So basically, the degree of intentionality is one of the main parameters to define the proper punishment. So we can see that in retributive justice theories, victims do not play any fundamental important role. Actually, they barely play a role because actually, if they play the role, this role is going to be kind of undermine the preeminent role that lies on the defendant and the wrong committed. Second theory, so some scholars maintain that granting procedural right to victims somehow is a mechanism aimed to achieve restorative justice. So if you go to just quickly to a rough definition of restorative justice, that is the process whereby parties with at stake in a specific offense collectively resolve how to deal with the aftermath of the offense and its implication in the future. An example, for example, is family group conferencing, victim perpetrator mediation. We can see so that if restorative justice has to be effectively implemented, it means that the defendant has to acknowledge at least the wrongness of his action, or it would be better if apologize, and has to sympathize with the victims and offer compensation for the wrongdoing and to heal the victim. But this requirement, which underpins the whole restorative process, is unlikely to occur in criminal justice before the ICC. Because if you think about the kind of perpetrators under judgment, we think that are very high-ranking political leaders or military leaders that clearly they still have political influence, or anyway have connection with other leaders, they still have political influence. So in this case, no one is interested is willing to apologize with victims or sympathize with them. Actually, this defendant generally are more willing to face a trial. And another requirement or feature of restorative justice is the cathartic and therapeutic experience of victim expressing the view of consent. But to be honest, at individual level, this cathartic effect, therapeutic effect, is very individual and is subject to variables that are difficult to foresee, and definitely is not a mandatory effect. So in my opinion, it's kind of misleading to mix restorative justice and victim participation in trial, because they can overlap, because clearly they share some aims, such, for example, enhancing victims' interest in truth, in justice, and participation. But definitely we see that there are different things. So, in my view, when I think that Expressivist provide a better understanding, a better answer to the challenges of victims' participation. So, what is Expressivist? So, it provides a kind of change in the perspective of the international of the criminal justice system. This switch is from the defendant has to be punished, we have to hold that defendants to account. So we can see this, the change in the perspective, the focus is from the punishment to the criminal proceeding, to the trial, to the process, whatever you can call it. So, and this is the focal point of bringing you to the attention, otherwise we are lost. So, expressivists advance a distinctive role for criminal justice system that is continuous to punishment, but is not reducible to that. That's what I mean. That so, of course, one of the goals of the trial of the criminal proceedings, also the ICC, definitely is punish the defendant because they committed atrocity, they deserve it definitely for the action that they do. But the focus is at the trial, and in particular the messaging values that the trial can convey. And these values are expressed crafting and historical narratives, and their authentication as a truth. And also building up a moral consensus and affirming the point that the societies compare to such a gross violation of human rights. So these values, of course, are all formulated in the preamble of the ICC. So there is a kind of match between expressivist and what are the goals of the ICC. And moreover, these values are even more enhanced when they take form, they occur through the rules of evidence within the criminal proceeding. And because of this, the expressivist value contributes to affirm eventually, ultimately, the authority of the rule of law. So, if we grant, so in this case, if we grant to victim participatory right, we can clearly understand that actually this participation is helping to clarify the event, to identify the perpetrators, the punishment, but mostly, this is my point, and they contribute to achieve these expressivist messaging values of the trials. Therefore, I believe that expressivist kind of expressivist theories like much better than the needs and the scope of victims' participation, because in this case, victims' participation is not seen as an element that goes against or undermines any other individual that is part in the trial rights, but actually is very consistent with all systems. So, concluding, so in my presentation, so I maintain that understand the primary goals of the criminal justice system is very important because, first of all, you can understand where the emphasis of the criminal procedure should lie on. And also it helps to shape the role of individuals, including the victims. And we saw that retributive and restorative approach to criminal justice fall short when they come to address the issue, the scope of victim participation. On the contrary, expressivist, advancing that the goals of the criminal justice system should be continuous but not reducible to criminal punishment, the trial became a means to provide a reliable and authoritative and impartial narrative and denounce the importance that society confers to serious violation of human rights, and ultimately the most important thing, to refute the authority of the rule of law. So shifting the attention from the punishment to the messaging values of the trials made it possible to fit in a consistent pattern the right of victims to access to and participation in the proceeding, and also together with the goals of the criminal justice system. Therefore, eventually, I just argued that the expressivist approach should inform the model of criminal justice system of the ICC, because at this point, I believe that victims' participation is worth to recognizing and to achieving. Thank you.
Thank you very much, Alessandra, for this excellent presentation and also for finishing on time.
Exactly.
Actually, 2 minutes before, that you cannot use. They cannot be given as a present. And now Elena Abrusci from the University of Nottingham will talk, last but not least, about whether and to what extent judicial fragmentation may crisis in international human rights law. 15 minutes for you.
Thank you very much. Thank you to Ben and Patrick for the occasion to come here and share with you part of my PhD research. I'm a PhD student in Nottingham as a second year. So what I'm presenting today is just some tentative conclusion of my thesis. So I really, really look forward for your feedback and advice and ideas. And I'm here trying to answer with you, I guess, to this kind of tricky question. So whether judicial fragmentation can be considered a sign of crisis for international human rights law. And differently from what Luis did this morning, where you kind of like try to provide a solution for an anti-fragmentation technique in the case of reparation, and just focusing on the phenomenon of judicial fragmentation and highlighting which are the pros and the cons, the negative and the positive aspects.
The other one?
Yeah. I'm going to highlight which are the negative and positive aspects and impact of judicial fragmentation. And together with you, I'm going to present you a case, a proper case of judicial fragmentation, and trying to assess whether it does produce a negative or positive impact, and how and if we can consider that judicial fragmentation in practice is a crisis or not for international human rights law, and trying to answer to our main question. I don't know how many of you are familiar with the concept of judicial fragmentation. Probably you're very familiar with fragmentation. That has been very well debated and discussed in international law, and the ILHRU report on fragmentation of Professor Consigliani is very popular. And fragmentation has always been considered as a main threat for international law. But what I'm considering here and focusing is not the whole fragmentation, but only judicial or institutional fragmentation. There is that phenomenon that arises when two courts, sides of the same matter, render contrasting or conflicting judgments. That basically means that two courts are interpreting differently the same rights. What I want to distinguish is like the phenomenon of judicial fragmentation from the one of normative fragmentation, because while normative fragmentation is the phenomenon where two different legal sources regulate differently the same rights, what I'm actually analyzing is only the cases where the legal sources, so for example, the ICCPR and the European Convention on Human Rights or the American Convention, are regulating in the same way, or very similar way, the same rights, but then thanks to the very wide margin of interpretation that is left to the judiciary bodies, those rights are in legal practice applied and interpreted in different ways. No. Okay. So what does it mean for international human rights law? Of course, applied within the regime of international human rights law, I'm analyzing whether this phenomenon is actually taking place between the three main regional courts, so the European Court of Human Rights, the Inter-American Court of Human Rights, and the African Court of Human and People's Rights. But of course, when in the case of the African system, I'm also taking into consideration the African Commission, since the African Court issued very few cases so far, so it wouldn't be enough for a comparison. And to keep an international level, also the UN Human Rights Committee case law. And even if the phenomenon of judicial fragmentation is not so big and so massive as one may expect, from a perusal of the case law of these bodies, it came out that fragmentation is taking place, as it may be noticed by the case law on the freedom to manifest religion, in particular when it comes to wearing the hijab in educational institutions, and using the Sikh turban in identity documents, and when it comes to indigenous property rights, as I'm going to explain you later. So the phenomenon is not so big, but is actually taking place. So what I'm going to discuss with you is which kind of impact does this phenomenon have on international human rights law. Of course, there are a lot of negative impacts and negative consequences. And probably that are the ones that are the most famous, because when we think of fragmentation, we think of the threat to unity, threat to uniformity and coherence of the regime. And actually it's true, because the lack of a clear hierarchy of sources and bodies makes the situation where two contrasting and conflicting judgments creates a lot of confusion and a lack of clarity about the context of the rights and the standards of protection that we have to adopt. Of course, when we don't know, when a court says that a right means something and the other court says that means something else, this creates a lot of confusion, since we don't have a body that can have the last word on the matter. And of course, this situation leads to a decreased judicial protection of the rights and decreased state compliance, because of course the state will find this situation of confusion as a perfect excuse for not complying with the not favorable conclusion of the courts or of the Human Rights Committee. Together with this, we have also the establishment of different regional standards. That means that people in different regional areas having their rights protected differently just because they are from Europe or from the Americas or from Africa. And is a very challenge to the principle of universality and equality of rights. And also the authority and legitimacy of the human rights system of protection that is put into discussion, because of course the human rights system of protection has already received lots of critiques, and confusion and lack of clarity in this matter and conflicted opinion within the same system, of course, is not helping the opinion that people have on that. And also the very unfortunate forum shopping phenomenon that happened a lot after the cases on freedom to manifest religion between the Human Rights Committee and the European Court of Human Rights, where of course the applicant is going to bring his case to the court, to the body that has, he knows that is going to have a very favorable, he's going to issue a very favorable opinion about this case. But however, the judicial fragmentation is kind of a coin and has two sides. If one side is the negative side, judicial fragmentation has also a very positive side. And as Bruno Simma said in a very brilliant article in 2001, people who blame fragmentation are people that are really conservative and scared of changing and scared of development. Because judicial fragmentation, it is true that it creates confusion, but it's also the only way, and really the only way, through which we can develop the case law, and international law and human rights law in particular need to be developed and continually developed in order to fulfill the local needs, and also changing and slightly different approach and application in the regional areas, and also adapt to the changing needs of society, because of course the convention has been and the charter has been applied into force in the 50s or in the 60s, but the society has changed and need to be then the protection needs to be adapted day by day. And also judicial fragmentation is the only way through which we can open a dialogue between all these bodies, courts and quasi-judicial bodies, for the achievement of the highest standard of protection. So once we analyzed, we saw that this coin has two sides, positive and negative, how we can, in the practice, assess whether a phenomenon of judicial fragmentation is having negative or positive impact, and whether it is a sign of crisis, or on the other hand, it's just a sign of a very positive development of case law and protection. So I'm bringing to your attention the case of the judicial fragmentation on indigenous property rights, between, on the one hand, the European Court of Human Rights, and on the other, the Inter-American Court of Human Rights and the African Commission of United People's Rights. All the three bodies have been discussed and issued judgment about very similar cases concerning the claim of ancestral lands by indigenous communities. But of course, their approach and their understanding of the right to property that is really similarly regulated in the European Convention of Human Rights, in the African Charter, and in the American Convention has been very differently applied, and their rights have been differently protected. On the one hand, the European Court of Human Rights has considered the two cases of the Inuit community in Denmark in 2006 and the Sami community in Sweden in 2010 as merely private property claims. So that's requiring to this indigenous community some proof of possession that it was a normal private property claim. And of course, both of these communities, they couldn't prove the possession of their ancestral lands by any piece of paper. And both cases have been declared inadmissible for these reasons. So those people had to leave their ancestral land. On the other hand, the Inter-American Court and the African Commission actually understood which is the peculiarity and the feature of the indigenous property rights. There's not a private property claim, but a collective property claim. And of course, the ancestral land and the claim for the property over the ancestral land should be understood as such. So not just a merely private property right, but as an umbrella right, under which all the rights can be achieved rights like the right to human dignity, human development, the right to adequate housing, and at the end, even the same right to life. And in all these cases, against Paraguay and Nicaragua, Suriname, and in the case of Africa and Kenya, of course, both the African Commission and the Inter-American Court ruled in favor of the applicants, thus protecting their rights to property. So, of course, here we have a clear judicial fragmentation on the matter, and we can assess differently. Of course, we can say there is a positive impact if we look from the point of view of the Inter-American Court and the African Commission, because they are actually setting a higher standard of protection. They're actually departing from the private property, classical private property conception of the European system, but also a lot of other countries, and they are trying to apply the property rights to the features of the indigenous community. However, the negative thing is that we cannot even play the time perspective and say that it has been an evolution, because as you can see, the first cases of the Inter-American Court in 2001, and then 2005 and 6, and so they were setting a very high standard of protection already in 2001, and then the European Court in 2006 took a step backward by reaffirming, no, it's just private property, and then the Inter-American Court and the African Commission took a step forward, saying, no, actually, collective property, we have to understand how indigenous communities are a particular entity. And then the European Court of Human Rights, again in 2010, stick to this position without learning anything from other regional systems and say, no, this is private property. So, of course, from this point of view of the European Court of Human Rights, looking at the European Court of Human Rights, this is a very negative situation, because, of course, we have a resistant and reluctant court that is not willing to learn anything from higher standard of protection set by other courts, and just keeping on this position. And what is really actually worrying is that in the long run, if we push for convergence, the convergence may happen, but may happen usually toward the position of the most powerful body. I don't want to engage in a discussion about which is the most powerful bodies between them, but the European Court of Human Rights will be very reluctant to align itself, as we've seen, to the Inter-American and African case law, and probably will try to force the other bodies to converse on them, especially in the case of the African Commission, that is really relying a lot on putting a lot and defending a lot to the European court case law. So, what is my conclusion is that does judicial fragmentation mean crisis for international human rights law? Not necessarily, because of course there is a lot of positive aspects in that, and indeed it shouldn't be demonized as such, because it has this kind of can bring a lot of higher standards of protection and actually be a positive improvement. But it definitely is a sign of crisis of international human rights law when it's not solved within a reasonable amount of time. So this fragmentation is protracted for a lot of time, and when it leads to convergence to a lower standard of protection. So in the case that maybe in the future we see the African court align itself to the European court. So of course, what we have to see to look forward for avoiding that judicial fragmentation is considered crisis, is always looking for the highest possible standard of protection. Thank you very much.
Thank you very much, Elena. Thanks to you for another brilliant presentation, and we can confirm now what we said at the beginning. We expect that it will be a very interesting panel. So what I would propose now to do is to open the floor to take some questions, and then yes, just a few questions, and then we have still 20 minutes if the organizer they say yes. So please.
I have to say that I actually kind of support the approach in that sense of the American system like that, and because I mean I see like in the most of the system of justice. So, because I see like I want in transition and justice, I mean, I cannot deny my work and areas of the plan, especially now, for example, I'm talking about property rights and transitional justice also you can make. I mean, I recommend the case of Nottingham and sections that actually they talk about massacres and also the importance of the property rights, especially but I wanted to ask specifically to Carina, the case of, because you talk about efficacy. I don't know, I remember a couple of years ago, I did the exercise to actually look at the reports and see the number of complaints of the issues of the internet. And I was surprised because you have this idea because you don't have like a strong compliance system like this, probably they will comply. And actually, I saw more than 80% of the countries were complying at least partially. But then I was thinking, like, what do you mean partially? And I could see that actually a lot of states were complying actually with the compensation. Also, almost the majority of the states in the middle of operations were, for example, complying with compensation. But I'm not sure that I would be what can you tell me that about like big institutional reforms or legal or constitutional change. I mean, of course, it's not familiarized as well, like the impact of this case and ultimate inflation. But I don't know about other cases specifically with amnesty laws. Because, for example, you say about amnesty laws, like for example, in the case of Mariniello, actually, Chile wasn't applying the law already when this judgment was issued. And we still have the amnesty law, but the courts are not applying that. And I'm thinking about the case of Brazil, for example, as well. I mean, you have this case of the Villa, and it's actually very important that we still have amnesty law. So, I don't know if you can tell about that, about like legal and institutional reform, the level of compliance comparing with
Thank you. Anyone else? Yeah. Sorry, you have to. Yes.
Thank you all for interesting papers. I have a question that's kind of aimed at Alessandra, but also I think Daniel as well, because there are some, I think this kind of touches on both, perhaps you might both be able to answer it. So Alessandra, in your sort of discussion of the Expressivist accounts, I thought there was some kind of inherent parallel between the messaging and the creation of narrative under that, as opposed to the ICC, that kind of seems to have some obvious sort of neo-colonial implications. And so I wondered whether that's something that you engage with at all in your research, as equally you should, and whether you could just sort of talk about the extent to which you have so far and your thoughts on it. And then perhaps, Daniel, if you maybe also, if you had any thoughts in terms of the fact that you've adopted this kind of perspective, perhaps to dialogue on that.
Yeah, thank you.
Thank you all for a very interesting presentation. My question is to Daniel. I have a twofold question. First of all, you seem to agree with this view that the ICC is particularly anti-African because it has opened most of these situations in Africa. How do you respond to the assessment that most of these states have referred the situation themselves to the ICC, and that some others have been referred by the Security Council? So in what way does that maybe alter your assessment of that? And then second of all, I'm quite familiar with the debate on 27.2 and Article 98 of the Rome Statute, but is it quite formalist? The formalist argument to say, well, the Security Council hasn't explicitly commanded Sudan to waive the immunity of al-Bashir, even though he doesn't have immunity before the ICC under customary international law. But they have ordered Sudan to cooperate fully with the ICC investigation. Couldn't we say, okay, so it's quite formalist to expect that they explicitly demanded them to waive that immunity, and therefore no other state should be obliged to arrest and surrender him to the court if he goes there for travel for political events.
Yeah, thank you very much. Yeah, I'm ready.
My question is for Daniel as well. Thank you very much for a very interesting paper. But I have a couple of comments as well for you to reflect on. I just wonder, the Office of Prosecutor has opened a number of investigations, cases into a number of African states. Half of those are self-referrals. And I just like you to comment briefly on how that feeds into your overall hypothesis underlying your thesis. And in addition to that, Kenya has shelved its exit plan to the ICC. It's made, that's been reported quite extensively within Kenya's media. But in addition to that, and just reflecting further on your hypothesis on the consequences that the Omar al-Bashir case has for international criminal justice, the South African Court of Appeal recently held that the South African government, acted unlawfully by allowing al-Bashir to leave South Africa. They made that decision back in March. Now, the South African government has obviously applied for leave to appeal that decision. But I'd like to hear your views on that judgment and what implications, what possible consequences that has for the Office of Prosecutor and ICC in its pursuit of al-Bashir.
Yes, thank you. We can start once. Yeah. So, we have already a few questions. Yeah, Carina, do you want to start?
So, thank you very much for the question. Yeah, regarding efficacy, it's difficult to find a definition for efficacy. But it certainly must be understood beyond compliance. First, because I read all the cases of the court, and I've been there for a while working in the court. So we have around 200 cases, a little bit more, and less than 20 were considered full compliance. Can you say that the court doesn't have efficacy because of that? No. Because if you look at the kind of reparations that the court sometimes imposes, the court already knows. And that these cases are going to take some time to be compliant. So if you look at the European Court, most of the reparations imposed by the European Court are compensation. The American Court will have deviations to reform a system to create a public policy. So yeah, you cannot understand the efficacy of compliance. And about amnesty, I think amnesty is one of the best cases to investigate. First, for example, the process of peace of Colombia now takes into consideration both international law as the case law of the American Court. So they already know that they cannot approve an amnesty law, and they respect that. And this is an impact that you are not saying, oh, but Colombia is compliant with some decision. No, it's not. But it's a very powerful fact. It's a very evident proof of the efficacy of the court. And regarding Brazil, yeah, Brazil is one of the countries that didn't impeach the Supreme Court actually after the decision of the American Court. The Supreme Court of Brazil upheld the amnesty law, going against the decision of the court. At the same time, you see that this decision creates the condition for local actors, for example, the Public Prosecutor Office, to start a series of litigation that are having some results. So again, if you look at these other variables that indicate efficacy, you can see that the decision did have some factors.
I'd love to answer a short, so we can take other questions. Then you want to go, you have quite a few questions. She's got the
Okay, first of all, just to be sure that we are on the same page about colonialism. So the way I understood your question, so basically you say, of course, is the narrative is shaped by a court that is in the Netherlands, and by a prosecutor, of course, run the risk to be a narrative by the colonialists. That is what you mean exactly.
Yeah, like sort of.
Just to be sure, because then we want to the answer. So, in my opinion, exactly this is the point of expressivist, because now I couldn't go into details really because 15 minutes is not that much. Exactly, if we provide victims with participatory rights, what I mean exactly, if the victims practically can, for example, challenge the decision of the prosecutor to drop an indictment, or challenge or present evidence during the trial, of course, they can risk or have a colonialist reconstruction of the event. Of course, there is still the risk, but with victims, there are population who suffer actually this situation. They can say their experience exactly is trying to find a balance, kind of, but that, of course, still, it would be, in my opinion, probably, it would be mostly a narrative, of course, by the kind of countries, but still with, exactly that's why my point before, enhancing victim participation can reduce this risk, basically. That's sorry, another question. Yeah, another question. Okay, let's go. Okay.
Yeah, on the alienation question, it's a great question. I think the writing of judgments in terms of having a cathartic effect and being for victims, I think it's deeply problematic in the sense that it's 3, 4, maybe 6 judges writing history. They're going to write from a certain perspective. Certain benches will be constituted by white, middle-aged men. Is it right they write history for victims? I'm not so sure. And again, so thank you for the questions. They're really, really helpful. African bias. So my work is focused on the office of the prosecutor in terms of what they do. But I don't think there is an African bias in terms of the selection of cases by the prosecutor. And there's a number of reasons for this. Horrendous crimes have been committed on the African continent. Some of them were easy targets. I think, why not? Why should the prosecutor go for those? But my point is that the judicial chambers have a responsibility to control where prosecutions are not allowed to happen. And the Bashir case is the example of that. The chamber should never allow it to go ahead because they don't think it is lawful, as I said, for the UNSC to strip out Bashir immunity in that way. And your question about is it formless? No. Well, first, let me start with the point that I don't think the referral, first of all, was able to strip immunities, actually. But then if we accept that it is, and we go to your question, should it have been explicit? I think, yes, it should have been explicit. It's doing such a serious thing, such serious consequences. It should have been spelled out. And I think it wasn't spelled out, because that's not what the members intended. And it wasn't what the members intended, I think, because if we look at it now, one, we see Russia and China being highly critical of the stripping of immunities. If they're being highly critical now, would they have accepted his immunity would have been stripped back then? I don't think so.
Why would they have passed the resolution in the first place?
Because they didn't intend that al-Bashir would have his immunity stripped from him. I don't think it was properly ever considered within the UNSC. Actually, if you look at the debates in the UNSC, it didn't come up. And I don't think it was implicitly envisioned that it would ever happen. But I think if you look at the fact that there's been no enforcement, despite the prosecutors coming every 6 months and saying, no one's arresting al-Bashir, the Security Council saying, we don't really care. If they cared, if they thought al-Bashir was going to be arrested, they wanted his immunity to be stripped, they would have acted as they have. And that says something about what they agreed about the resolution was passed. So, and thank you for the question. They're really, really useful. Hopefully, the OTP question I kind of addressed that. I don't really deal with that. I think the OTP should go ahead and do what it wants. I don't agree there's selective bias, but the point about DRC being self-referred, the self-referral, yeah, actually, there was a lot of behind-the-scenes badgering by the ICC to get those cases. DRC didn't come to the ICC and say, please take our case. Reino Campo is there doing a lot of work on the ground, getting those cases to court. Can you show the exit plan? Yeah, it's quite the leverage.
Yes, it has proposed a number of reforms instead, and the UN General Assembly has been considering those.
Absolutely, I think that's exactly what it's doing. First of all, came out hard, tried to get some leverage, now said, right, well, let's work together. But it's not going to last. I don't think it's going to change anytime soon. This development of the roadmap, and that's control, is still bubbling in the background, and I think that's going to continue to be a shadow. These debates are going to shadow Africa's relationship to the ICC for some time to come. The judgment of South African Court of Appeal, it's a very poor judgment. It essentially follows what the ICC has said. And again, has repeated the same mistake. So it doesn't interrogate why they say the ICC has the power to strike immunity, which is fundamentally why it's so contested. If the judges aren't going to grapple with that question, well, it's not appropriate not to address that, to say explicitly what the legal basis is.
Thank you. I think we have still just final 2 questions because we are most going to.
How would expressive is respond to the issue of choice and obviously you
Yeah, sorry. Take off the other one. Yeah, it's not on them.
As well, I'm sort of following your arguments. If you're saying is that this falls under immunities or 10%, but that's not how, in my view, immunities or 10% operate, because the underlying principle is that of the sovereign equality of states and international courts and tribunals, that may be different. And in any case, the only present example of this is Nuremberg. And then you are able to lead us to arguing that Nuremberg also illegally stripped from immunities these people. But if you're right, and I'm not an expert in criminal law, then you would also have the same problem with immunities Russian materia regarding nationals of not-party states to the Rome Statute committed crimes in the territory of states parties, because they would be in many cases covered by immunities Russian materia. So the problem then is way bigger, and it would make the courts, as project, unless a different project, a project with a lesser scope. So I don't know if you understand my question.
Yeah, thank you very much. Just 1 minute. Yes, Daniel, do you want to say something?
Yeah. Thank you. It's a great question. When I did my research, I bracketed off, perhaps wrongly, but just to make it manageable, bracketed off rational materia. So I didn't consider that, so I can't really talk to that. Your last point about limiting the scope of the ICC. Yeah, I mean, I think it's right though. The ICC scope is limited. It's that's the system that exists within them. This is one of the core arguments in my work. The ICC shouldn't try to be something that it's not, because that's what it's tried to do in Bashir. The consequence of that is it's put its existence under threat. It has to accept that it operates in a state based system. It has to respect international law. It can't go and chase this cosmopolitan dream when the system that's within doesn't allow it to. The question about whether Nuremberg is wrong as a result of this, I'll have to think more about it. But no, my initial reaction is no, because it's a very different system. Nuremberg was created in very different terms to what the ICC is created. But I'll have to think about it.
Thank you. Alessandra.
So, okay, the children soldier. To be honest, I don't deal my research with children soldier, but however, I think that the answer you have to ask for is just that before just children soldier, can they take part in this proceeding as witnesses, as victims, or as perpetrators? Of course, I think this is the divided, and that's so. To be honest, it depends, of course, on the case, of course. But once, for example, they're admitted to trial as victims, then I really believe they should exercise all the rights, procedural rights compared to other victims. So it is my point is the step before the issue. They can take part as victims or not. I think it's a case law definitely. Then that's the question.
Yeah. I'm just that is a good question.
No, thank you, because I didn't think to deal about specifically this specific victim. My research general victims.
No. But if we assume we're talking about the child defendant, expressivism, as you said, goes on setting history straight and sending a message, right? So obviously the entailing punishment would be very, very serious. Like, would you say it's excessive in the case of...
No, I didn't say the punishment is serious. No, I didn't say that. I mean, what I said, my argumentation just challenged that if we focus the criminal justice system, the SEC, on punishment, is reductive. Because, of course, if we're talking in a retributive sense, of course, we cannot, but I think we shouldn't even punishing proportionally, punishing the defendant in proportion to what they did, of course, because really there's no proportion, probably, But except so if we focus just on punishment, the goals, all the ICC system is quite reductive. That's why we have to find something else for that, because if you just focus on the retribution or also deterrence, to be honest with you, because at the end of time, also deterrence, is very limited. It's very limited the scope of deterrence in international criminal justice system. That's why we have to do something else. So the children, soldier depends how they are considered. That is depend on the case. That's the.
I think there's a place for victims in retribution.
I don't. To be honest,
Is there a place for victims in the
to be honest, I just did the fair hearing. So retribution systems, I don't know.
But so I would like to have a question. Let's keep on going with this topic, which is very interesting. I remember there was a single judge decision in 2008, Tanga case. I think single judge Sylvia Steiner. She said, the second point, this decision, that victims have a right to suit. Okay, I mean, this is more or less your research about. No, I mean, it's the relationship very interesting between criminal law and history, which is not something new in international criminal law. In many domestic systems we have discussed about. Then this concept has never been implemented by other judges. I don't think there are other decisions. If you look at the Kenya cases, I think single judge Triestino has been quite critical of this existence of this right. Why? For a very simple reason, because recognizing victims' rights to suit in international criminal justice can have a serious impact on the life of the accused, or the suspect or the accused, depending on the stage of the proceeding which we are talking about. So my question for you is, building up a victim-centric system, do you investigate the potential consequences that this can have on the lives of the accused? At the end of the day, is the main actor on the stage of a criminal justice or international criminal justice stage.
Okay, I think there is a misunderstanding. I don't really want to build up a victim-centric system. It's a system where victims also can play a role, but it's different. Probably it's different than the immediate victim has to be the center. It has to be one of the parties, that's for sure. So, of course, there are, actually, I still at this stage, but I was analyzing the case, the Abrusci case before the Extradition African Court. And I think this is a good example because, of course, they took, I think, eventually more than 1,500 victims took part in the proceeding. It's not okay compared to the SEC, probably it's not a huge number, but still it makes the deal that this part took part 1,500, something like that, took part in the proceeding as civil parties. Nevertheless, so the representatives, they were presenting evidences, challenging decision, and nevertheless, the trial lasts less than 1 year. Actually, the decision was end of the 30th of May, actually, if I'm not wrong, and the trial started in April 2015. So I think this is a good example. Okay, the number still is rather not broad compared to ICC, but still the trials, the criminal trial for the former diplomat child, of course, was accused of war crimes, crimes against humanity, and it lasted only 1 year with victims to part as civil parts. I think this is a good example, actually, that shows that actually this concern that the rights of the accused can be undermined, threatening. I think it's not a mandatory outcome, definitely.
Okay, that's great. Thank you very much. Just to conclude, as also being asked by someone, and I said at the beginning, I said at the beginning, I referred to the concept of African International Criminal Court. Just to clarify what I was saying, that I didn't mean that, well, we have now huge evidence that in this context, in this situation, that we committed serious violation of human rights amounting to war crimes and crimes against humanity. We will see for genocide if the Sudan Darfur cases will keep on going before the SEC. What I was saying at the beginning is that the problem is not where the prosecutor opened the investigation, but the problem is where we did not do it. That was my point. So this is what I mean for critique to the sacred legitimacy of international criminal justice. And for this reason, I refer to the situation in Palestine, but we could keep on going for hours. Let's talk about the Iraq situation, for instance. What I was saying before is that in many circumstances, the prosecutor has used, or better to say, abused the concept of gravity, which is within the law stated in Article 17 and Article 53, in order to avoid to open investigation in situation which could be, let's say, create political problems to the ICC at an international level. But we can discuss about it in a couple of hours in our paper if you want. Thank you very much for your time. It was a great panel, very interesting. Thank you very much.